Welcome to Trial Lawyer Prep, where trial lawyers learn how to better connect with clients and juries, gather tips and strategies for better persuasion, and how to use focus groups in the process. I'm your host, Elizabeth Larrick, and in today's episode, we're going to tell you what trial lawyers wanted to hear in 2025. 2025 is wrapping up, and before we head into the new year, I want to look back at what resonated with you, and more importantly, what I learned from the dozens and dozens of focus groups that were conducted this year that I think every trial lawyer needs to know. You made some clear choices about what you wanted to hear, so let's jump into your top picks from the podcast and then move into the patterns that I saw. Top pick for the podcast was guest episodes. Now, these were fantastic episodes about jury selection, assessing risk, and even time management. So our top picks were episode 149 with Sharif Gray, where he and I talked about challenging traditional voir dire methods with research-backed alternatives. Another great episode was 138 with guest Ben Gideon, where he talked about assessing risk for trial lawyers, a few tools to do that. And also Dina Cataldo's episode 133, which was time management for lawyers. Now, these were top picks not by me, but by consumption rates, which were over 75% for each of these episodes, which tells me you enjoyed them and got wonderful pieces of advice from them. So a link will be in the show notes for each of those episodes. Now, another top thing that came out of the podcast this year were 3 specific topics, again, with our statistics not lying, over 80% consumption. So we saw trial strategy, witness prep, and persuasion as the top listened to topics, but let's dive into those specific episodes. So if you want to go back and re-listen, you certainly can. For trial strategy, we had episode 131. What is trial strategy and what it is not? Now, this clarified the difference between strategy and tactics, which is a pretty big one for lawyers. But one of the key takeaways was doing our strategic thinking early with focus groups. Now, this brings me to something that I see almost every year, but especially in 2025, as even more lawyers went to trial, was waiting to do those focus groups in the 30 to 45 days before trial. And this is where we could be missing out on testing things early in order to make corrections. This is exactly why I encourage lawyers to run early focus groups during discovery, when you can test strategic frames, try some tactics if you want, early though, so you can course correct before you're locked in. If you're heading into 2026 with a trial scheduled or a big one going to mediation, and you want some strategic clarity, let's talk about scheduling a focus group. You can book a free consultation call with a link in the show notes. Now, moving to witness prep, we had episode 143, which was rewiring your witness prep with brain science. This was a great episode if you have a deposition coming up or even a trial, with how to make your witness prep more effective with 3 simple tips. And again, that link will be in the show notes. And finally, our top episode for persuasion was episode 144, the 8-second rule. This taps into the what we know to be so true, but primacy. We have about 8 seconds to grab attention and then the next 43 to keep it. If we don't get our audience's attention during that time frame, it is an uphill battle to get them to hear what we are saying and also understand it. And that's for any audience that we're talking to. Jurors, judges, mediators, even your client. So this was a great episode and the link will be in the show notes. This particular primacy point is something that I talk about often. And a recent post on LinkedIn that a lot of people appreciated was a story I told about a lawyer who was practicing their opening statement with me and started out with reciting a piece of law from a very famous law professor. And I had to stop him because people were going to be lost, right? The judge would have been lost, jurors would have been lost. And what happens is our brain is trying to figure out what is he saying and why is he saying? And while our brains walk around confused, trying to figure out what they're saying. They don't hear anything else in your opening statement. So we don't want to do that. So I stopped that lawyer. We went back and refashioned that opening to make sure we grabbed that 8 seconds, kept him for the 43. His opening started with the bang, and he felt so confident in the point he was making in the first minute that he was able to echo it, again demonstrating this is important, y'all. We're going to say it again throughout the trial. So we want to start out with a bang. We want to grab that attention. That episode 144 is a great way to refresh on that point. Now, let's talk about the trends from focus groups in 2025. Again, over 75 focus groups conducted. And so these were some of our main takeaways that we saw. Number one, visual is always important, but the more fine-tuned point was comparison. So we see comparison in almost everything we do. Scroll on Instagram, going to pick a car, everything has a side-by-side comparison. And so the pattern that came across from multiple focus groups was that jurors were really struggling to understand the both sides when it was just a verbal presentation or had a few visual aids. Commonly used visual aids that reiterated this point were property damage photos, right? They're using those photos to compare to injuries, to compare to what people could explain how the crash happened. Our brains love visuals. 60% of our brain is dedicated to understanding visuals. So we love them. But also when we have that side-by-side comparison, we are making it easy. Our brains love it easy. And then it gets fast, right? So we want our audience to quickly be able to evaluate and find in our favor. So one of the things we've talked about is when we have a comparison, maybe it's a fact pattern versus the safety rule or the standards or the norms. That's a super important way to visualize that comparison for our audience, whether it could be jurors or even in our focus groups. But also another great one is experts. We see dueling experts in almost every large case, almost every case. There is a dueling expert. Maybe you have one, maybe they have one, right? They're fighting it to the death. And a lot of times as lawyers, we put a lot of credence in what experts are saying. Focus groups, not so much. But a way to test it, because I know this is a strong point for many trial lawyers wanting to test experts. Are they going to follow the other one? Are they going to follow this one? Right? What is it that they're doing that maybe is swaying our jurors? Doing a side-by-side comparison, right? Where you distill down what the expert did, what their opinion is. Credentials don't really matter, right? It's really about what did they do and what was their opinion, and distilling that down onto one PowerPoint slide or one visual significantly helps them be able to quickly evaluate and give you feedback. Helpful tip for focus groups, but also very helpful for a jury trial, and that visual aid can be used again during cross and in closing. All right, let's move to our second trend that came out of our focus groups, which was emotional detachment. When I say emotional, I mean like maybe they're tragic facts, maybe they're egregious defendant conduct, and it just fell flat, right? No emotional movement. This particular red flag was more predictive of a no juror, a juror you would not want, than some of our demographics. So tracking that early, putting some of those things in early to test emotional feedback and jury selection is one of the biggest tips that we saw. But another piece of interpretation on that emotional flatness. Occasionally, or sometimes both, it detects our no jurors, but also detects a big block that's missing, a gap in education or just overall knowledge and experience. Story recently saw this where our jurors were falling completely flat. We had tragic facts. We had a defendant clearly ignoring safety rules and a safety altogether, but nothing was jiving. As the discussion kept going on and the feedback continued, it became apparent that they were very clueless about the industry of the defendant. So we said, all right, what's our takeaway? We got to educate early and often, just to make sure they're not making the wrong assumptions about this industry or comparing it to industries that are completely skewed and would be skewed against you. Okay, Our last trend from our focus groups would be lawyers underusing your focus group investment. I see this where lawyers will sit in, take notes. They're super excited and enthused after we have our focus group strategy session, and then nothing. They don't go back and revisit the transcript or the focus group reports. And I know this because I am able to track when people are downloading and using those things. Now, this is a huge point for me because when I spent a year with the Keenan Law Firm, one of my largest takeaways was the gold that was lying in those focus group transcripts and reports. I do this for the reports for my clients, but also you can do this just with going back and rereading the transcripts. We would spend hours going back to focus group reports and transcripts in order to find, okay, let's get back in there. What were they saying? What were the exact words? Can we work those words, those phrases into opening? Can we work those words and phrases into deposition questions? What was their attitude? For, against us? How do we use that to our benefit? Also, what were some of the main questions that they had when they were just talking, right? Free flow conversation with them, not necessarily that pointed, what was missing here? Sometimes people draw a blank when we ask that question, but if you just go back and read through the transcript, you will see when things are missing, people naturally percolate. They'll tell you that first, or it'll naturally percolate for them in just conversation and then listening to other people as well. So that's a huge point. We want to make sure we get from our focus group transcripts, we don't miss it. So if you have something coming up in 2026 and you ran a focus group in 2025, go back, reread that transcript. You will glean so much more information out of that group. And again, this was a large investment, so let's use it as much as we can. This just taps into the point that our brains can't focus and concentrate on all things that are happening. We're not going to see all the body language that's going on. We're not going to be able to take down a note and hear what every single person is saying. Again, that's why that transcript is so helpful to make sure you didn't miss anything. Okay, so let's recap what you loved in 2025. Guest episodes, trial strategy, witness prep, persuasion, and our top trends from our focus group. Comparison, but use of a visual, emotional flatness, detecting that, and then also going back and reusing our focus groups and squeezing as much as we can out of that focus group investment by rereading those transcripts. Now, as we look ahead to 2026, I am very excited to bring you more content on trial strategy, on guests, on other things that we can be doing to improve our preparation, which brings me to, don't forget that I have an email newsletter that provides more how-to and tips once a month to your email inbox. You can sign up for that newsletter in the show notes. All right. Thank you so much for making 2025 so amazing for me. I love learning from you, and I love providing what I can back to my longtime listeners and to folks who are just coming to the podcast. I appreciate either way, you being here. And if you want to start off 2026 with a focus group, you're curious about it, don't forget to book a link in the show notes. All right, until next time, thank you so much.